Good morning. Hinda Klein here on behalf of the appellant. We have two issues before the court today. The first is whether the JCC erred as a matter of law in failing to address whether Mr. Bartoles' requested surgery was causally related to his industrial accident because it was ripe for adjudication and properly raised as a defense. Now, the court will note that nowhere in the JCC's final order does the JCC ever address that issue. The JCC only addresses the medical necessity of that surgery. The JCC was required to rule on all of the issues properly raised, and there's no dispute on this record that it was, in fact, properly raised as a defense and litigated. Where the JCC errs as a matter of law in presuming that a causal connection exists between an industrial accident and a physical condition necessitating the surgery, the JCC's order must be reversed as a matter of law. This is not a question of competent substantial evidence. Now, opposing counsel argues in his answer brief that the JCC found that Drs. Webb and Delgado both opined that the accident only aggravated his pre-existing condition. However, Dr. Webb didn't review the April 20th 05 MRI by Dr. Moreno, and in fact he testified that he relied solely on Bartoles' oral history, which didn't include a mention of a subsequent motor vehicle accident or an MRI in 05, which indicated that his prior herniation had resolved. And Dr. Delgado, while he testified only as to the necessity of the surgery, did not make a causal connection between the industrial accident and the need for surgery. Given that the JCC was charged with addressing all of the issues raised, not only the medical necessity of the surgery, but the causal relationship between the accident and that surgery, and the JCC did not.
Well, to the extent there may have been a deficiency here, was it cleared up? Was it not cleared up in the order on rehearing?
No, it was not. The JCC insisted on rehearing that the only issue before her was the necessity of the surgery and did not address the arguments that we raised throughout the proceedings and on the motion for rehearing that the causal relationship was very much an issue. The order on rehearing did not address that at all. Our second issue on appeal is that the JCC erred as a matter of law in failing to permit the EMA to review all of the medical records of Mr. Bartoles. Dr. Shulak, during his deposition, which was only a few weeks before the final hearing, indicated that he did not have a number of records that post-dated the motorcycle accident in this case. And he repeatedly testified that had he had those records, his opinions, both on the causation of the injury as well as the need for surgery, may well be different. Now, shortly before the final hearing, the employer carrier moved the court to continue the hearing and to permit the employer carrier to provide those relevant records to Dr. Shulak. And the court denied the motion to continue the hearing, but agreed that the EC could, in fact, send those records to Dr. Shulak after the final hearing if the JCC believed them to be relevant. Clearly, Dr. Shulak's testimony, which is on pages 1025 through 1028 of the record, indicates that those records were crucial to his opinion, not just on the cause for the surgery, but the cause of the claimant's condition in general. And he couldn't have been any clearer about it. Again, that was something that was timely raised on the motion for rehearing, but the JCC declined once again to permit Dr. Shulak to review those records, finding that there was, in fact, no dispute as to the causal connection between the injury and the need for surgery. That is absolutely contrary to this record, and I believe that once the JCC has decided that there is in fact a conflict and appoints an EMA, it is nonsensical for the JCC thereafter to not permit the EMA to render the exact opinions that the JCC herself has requested. So we believe that the court should reverse and remand this case to the JCC for further proceedings and to enable Dr. Shulak to have all of the records necessary for his decision. Thank you.
May it please the Court. My name is Bill McCabe. I represent the claimant, Peter Bartoles. When I hear the arguments of counsel for the employer carrier, it makes me think we've almost read different records in this case. Their first position is that the judge doesn't determine or doesn't address the employer carrier's argument that this motorcycle accident that happened in 2003 is the major contributing cause of the claimant's current low back condition, which is a herniated disc at L4, L5. The judge clearly addresses that argument. On page 1336 of the record, which is in the judge's final order, the judge says that Dr. Webb, Dr. Delgado substantiate that the motorcycle accident caused nothing more than a temporary aggravation of the claimant's condition and that the condition has returned to baseline. Now, if there's any doubt about that, the judge in her order on denying the employer carrier's motion for rehearing and motion to vacate is crystal clear on it. She says the final compensation order found that the claimant suffered a lumbar disc injury as a result of the industrial accident and that all MRIs except one show the same disc at L4-5 before and after the motorcycle accident. Both Dr. Delgado and Dr. Webb testified that the motorcycle accident was only a temporary aggravation of the herniated disc that was causally related to the industrial accident. The testimony of Dr. Delgado and Dr. Webb on this issue was accepted as correct in the final compensation order. As such, the need for treatment is causally related to the industrial accident. It seems crystal clear. And I might point out that there's competent evidence to support that. There's Dr. Webb's testimony, and by the way, Dr. Webb's opinion is not just based on what the claimant told him. Dr. Webb was given the records by counsel for claimant back to 2001. Dr. Webb noted that there was a 2002 MRI that showed the herniated disc at L4, L5. And Dr. Delgado opined the major contributing cause of the claimant's low back condition was the industrial accident. He just didn't think that surgery would be appropriate for the claimant. There's the conflict between the two doctors, and the appointment of an EMA as to address that conflict was certainly appropriate. And the EMA, Dr. Shulak, enters an opinion that the surgery is medically necessary. I might also point out that there is no requirement in this record for Dr. Shulak to review any other medical records to determine whether the claimant needs surgery. Dr. Shulak stated 3 different places in his deposition, page 1025, 1028, 1033 of the record, that when I saw the claimant on May 30th, 2008, he would benefit from surgery. That's his opinion. And since that was the issue, the main issue in this case, the main conflict between the two doctors, there's no need for Dr. Shulak to look at any additional records. He had sufficient information based on his examination of the claimant at that time to determine that the claimant did, in fact, need the surgery. So the judge in this particular case accepted the opinion of the EMA, which the judge is required to do absent clear and convincing evidence to the contrary, that the claimant needs the surgery, that it's medically necessary. So we feel that there's absolutely no reversible error in this case, that the judge's rulings and orders are in accord with applicable law, and this judge's order should be affirmed in this case. Thank you.
The issue of the causal connection between the accident and the surgery was very much an issue, and Dr. Delgado did not address it. Dr. Webb did not have a number of the medical records, and Dr. Shula was very specifically asked to opine on that issue. The court, in its letter to Dr. Shulak, after she granted our motion for an EMA, said that there is a conflict between Dr. Webb and Dr. Delgado over whether or not the claimant needs a laminectomy infusion, and if so, the major contributing cause of the need for surgery. There is also an issue as to whether or not the claimant has reached maximum medical improvement, and if he has any restrictions on his ability to return to work. As such, I'm asking you to address these issues after you have evaluated them. Now, during Dr. Shulak's deposition, he repeatedly not only said, I haven't seen a number of these records before, but he said my opinion on major contributing cause could in fact be different after I review these records. Given that the JCC referred this specific issue to the EMA for resolution, and the EMA specifically testified he needed these records to make a final opinion, it is just nonsensical for the JCC to thereafter say, well, I didn't mean for you to address that issue, and I'm going to ignore it entirely. This order must be reversed as to both issues. Thank you.